showing a title graphic that says Tennessee Department of Children's Services, Hipaa, the Health Insurance, Portability, and Accountability Act of 1996.
HIPAA stands for the Health Insurance and Portability Act of 1996, is also called the Privacy Rule. The purpose of HIPAA is to provide a balance between confidentiality and appropriate disclosure of protected health information, or PHI. There are three primary questions to ask to determine whether HIPAA applies before disclosing confidential information. Am I a covered entity? Is the information I am requesting or disclosing classified as PHI? If the information is PHI, how do I legally disclose it?
DCS is a covered entity because it provides health services to children and youth and receives payment from the Bureau of TennCare. PHI is defined as all information a healthcare provider either creates or receives that either identifies an individual or could reasonably identify an individual. The information must also pertain to that individual's past, present, or future mental or physical condition, provisions of care the individual receives, and the past, present, and future payment for those provisions of care. PHI does not include identifiable health information in educational records covered by the Family Educational Rights and Privacy Act and employment records held by the covered entity. Disclosures. 1. Disclosure means to release, transfer, have access to, or divulge information in any manner outside of the entity that keeps it. 2. Disclosure can occur verbally, electronically, and physically, paper documentation. Minimum necessary standard. In the majority of cases, disclosure under HIPAA requires the minimum necessary standard. Minimum necessary standard means the CE can disclose the amount of information necessary to accomplish the intended purpose of the disclosure. Therefore, be sure that requests for PHI are specific and state the purpose of the disclosure. When a minimum necessary standard applies, a covered entity cannot use, disclose, or request the entire medical record unless it can justify why the whole record is needed to the purpose.
A covered entity may not use or disclose protected health information unless disclosure is made for the purpose of treatment, payment, or the provisions of healthcare operations. Disclosure is made to the individual requesting his information. Disclosure is done pursuant to a business agreement. Disclosure pursuant to one of the 12 exceptions, or disclosure pursuant to a valid authorization to release information. A valid release must be in writing and must contain the following core elements: a specified description of the information to be disclosed or used, the name of person, class of persons, or entity authorized to make the request, and proof of their authority, a specific articulation for the reason this information must be disclosed. Name of the person, class of persons, or entity to whom the covered entity may disclose the PHI. An expiration date for the duration of the authorization. Individual's signature and date. Notice of the individual's right to revoke the authorization in writing. The covered entity must provide a copy of the authorization to the individual. There are 12 instances when covered entities may fully disclose PHI without an authorized release. Required by law includes, but not limited to, the following: court orders, court-ordered warrants, subpoenas or summons issued by a court, a government or tribal inspector general, an administrative body authorized to require the production of information, Medicare conditions for participants with respect to health care providers participating in the program. Information regarding victims of abuse, neglect, or domestic violence can be disclosed to government entities that customarily receive this information. A covered entity may disclose PHI in response to a court order or administrative tribunal as long as it discloses only the PHI that is expressly authorized in the court order, or, in absence of a court order, a covered entity may disclose PHI in response to a subpoena, discovery process, or any legal process. Covered entities may disclose PHI that they believe is necessary to prevent or lessen a serious and imminent threat to a person or to the public. Covered entities may disclose PHI to law enforcement if the information is needed to identify or apprehend an escapee or violent criminal. Covered entities may disclose PHI in compliance with the compensation laws and other similar programs that provide benefits for work-related injuries. Disclosure to public health authorities authorized to collect or receive information for preventing or controlling disease, injury, or disability. To public health or governmental authorities authorized to receive reports of child abuse and neglect, and entities subject of FDA regulation for documentation of adverse event reporting, tracking of products, product recalls, and post-market surveillance. Public health exceptions also include persons who may have contracted or have been exposed to a communicable disease when notification is authorized by law, and when employers request information on employees for information concerning work-related illness or injury or workplace-related medical surveillance as required by the Occupational Safety and Health Administration, OSHA, or any similar state law. A health oversight agency is an entity that is authorized over healthcare systems in which health information is necessary to determine eligibility, compliance, or to enforce a civil rights law for which health information is relevant. Generally, this exception is used for government benefit programs such as eligibility. A covered entity may disclose PHI in only 6 instances for law enforcement purposes: as required by law, to identify or locate a suspect, fugitive, material witness, or missing person, in response to a law enforcement request about a victim or possible victim in a crime, disclosure by a covered health care provider in a medical emergency occurring off the covered entity's premises, to alert law enforcement of a person's death if the covered entity suspects that criminal activity caused the death, when a covered entity believes that PHI is evidence of a crime that happened on its premises. A covered entity may disclose PHI to funeral directors, coroners, and medical examiners for the following purposes: to identify a descendant, to determine the cause of death, and to perform other functions as required by law. PHI may be disclosed to facilitate the donation and transplantation of cadaveric organs, eyes, and tissue. For exceptions in research, covered entities must receive one of the following 3 things before disclosure: documentation that the Institutional Review Board or Privacy Board has approved an alteration or waiver of the person's authorization, or proof that the PHI uses in research will be used only to prepare a research protocol, and that the researcher will not remove any PHI from the covered entity, or that PHI is necessary for the research to be complete. Exceptions are made for essential governmental functions when assuring proper execution of military functions, conducting intelligence and national security actions, providing protective services to the President, protecting the health and safety of inmates or employees. State law preempts Hipaa federal law in 5 instances: when it is necessary to prevent fraud and abuse in relation to payment of health care, when it is expressly authorized in regulation of insurance plan and health plans, when it requires the reporting of health care delivery or cost, when it regulates the manufacture, registration, dispensing, and distribution of controlled substances, and when state law is more stringent in protecting confidential material. Everyone should be careful about disclosing PHI because there are penalties. Civil penalties include a $100 fine for each Hipaa violation. Civil penalties cannot exceed $25,000. For criminal penalties, a person can be fined up to $50,000, imprisoned, or both. If wrongful disclosure is committed under false pretenses, the offender can be fined up to $100,000, imprisoned for up to 5 years, or both. If the wrongful disclosure is committed with the intent to sell, transfer, or to use identifiable health information for commercial advantage, personal gain, or malicious harm, the offender can be fined up to $250,000, imprisoned for up to 10 years, or both.